4, and the second one is the paragraph 26(6) under the Employee Provident Fund Scheme. So Supreme Court judgment dated 4/11/2022. The second thing we will discuss in this webinar is the 11.3 and 11.4. The third thing is the who are eligible to get the higher pension and who are not. Fourth is the documentation submission part, because this is also somewhat confusion is there. So we will also discuss about the documentations part and everything. So the important part in this is there was no cutoff date. As we go ahead, I will also brief about the 11.3. So in paragraph 11.3 under the employee pension scheme, because in Provident Fund Act there is a 3 scheme. The first scheme is the Employee Provident Fund Scheme. The second is the employee pension scheme, and the third one is the EDLI scheme. So in this, the para 11.3 under the employee provident employee pension scheme, there was a no cutoff date to submit the joint declaration. If your pension is deducted on the higher side, so you have to intimate to the authority that your pension is deducted on the higher side. But in paragraph 11.3, there was no cutoff date that once you will be the member of pension, then within this period, if your pension is deducted on the higher side, so within this time period you have to submit the declaration. So it was not there in 11.3. So paragraph 11.4 will be applicable to employee exercise option under the 11.3 of 1995 and continue to be who are the member of the pension from the 1995 till 95 to 30th August 2014. The para 11.3 was the existed, and after that 11.4 was come into the picture from the 1st September 2014 onwards.
Jay, you have gone frozen.
So in this, the second point was important. Hello.
Sorry,
I'm audible.
Yeah, now you are. There was a break in between that you were not audible. Okay, go ahead. I think now we can hear.
Yeah. So in 11.4, they have introduced the new part that was not prior to 1st September 2014. If any employee is contributing the pension on the higher side, there are some of the few organizations whose employee has been contributing the pension on the higher side, that is not restricted to the 541 rupees or 1250. So in on 1st September 2014 onwards, they have said that the 1.16%, for example, now your basic is 30,000 rupees is there. Okay, so up to 15,000 there will be no contribution paid, additional contribution paid. But after 30, for example, 30,000 is there, up to 15,000 central government will contribute 1.16%, but remaining 15,000 the employee has to pay the additional amount, that was the 1.16%. But in judgment, Supreme Court judgment, it said that this was the illegal. In the act there was no mention that additional amount has to be taken from the employee. So for this they have given the 4 months time to refund this amount, and from where they can take the amount, internal government. So 1.16% was the illegal. It was clearly mentioned in the Supreme Court judgment. And this is for the employee. The same rule will be applicable for the judgment is same for the exempted employee also, exempted organization, the organization who is falling under the trust. So for them also the rule will be the same for getting the higher pension. So now we will come to the differentiate between the 11.1 and 11.2. then 11.3 and 11.4. So prior to this notification, the prior to notification first, which was effective from the 1st September 2014, 11.1 was the to calculate the monthly pension, the average span of 12 months has to be taken, which was changed in the 11.1 after from the 1st September 2014. The employee to calculate the monthly pension, the pension department is taking the span of 60 months, the average 60 months they are taking the average basic whatever the pensionable wages has been taken. So prior to the 1st September, it was only the 12 months average was be taken and calculate the monthly pension. But from the 1st September 2014 onwards, it has to be increased by 60 months. Instead of 12 months, it was increased to the 60 months. It is mentioned over here. Then 11.3. So now this is the important part. So 11.3, what was the 11.3? The maximum pensionable salary limited to 6,500 per month. This is important, provided that if at the option of the employer and employee contribute to paid on salary exceeding 6,500 from the date of commencement of this scheme, or from the date of salary exceed the 6,500, whichever is later, 8.33 share of employer thereon is remitted on the pension fund. So from the day one when this scheme was introduced, the 11.3 para was introduced, where it is clearly mentioned that if any employee want to contribute on the higher side above 6,500 rupees, so he can by the mutual understanding of employer and employee, he can just take this option by contributing on the higher side. Right now PF में सबको पता है कि PF has been deducted on the higher side, but even in the pension scheme it was there under para 11.3. If any employee want to go for the higher contribution, that is above 541, then also he can go through the 11.3. So this was the 11.3. So 11.3 was existed till the 30th August 2014, and then they have introduced the new para, that was the para 11.4. So 11.3 was existing para. Now they have removed that para and introduced the new para, that was the 11.4. So in 11.4, there was the cutoff date they have given. In 11.4, they have given the cutoff date that this is the important part, provided that a 4-member have to contribute at a rate of 1.16% on the salary exceeding the 15,000, which we have discussed earlier, that if any employee want to go for this option, that higher one, then they have to contribute additional whatever the amount they are contributing on the higher pension. For example, pension is contributing on the 20,000 rupees, so up to 15,000 it will be by the central government. Remaining on the 5,000, the excess amount 5,000, the employee has to contribute 1.16%. So this was already mentioned in the Supreme Court judgment that this was the illegal part. 1.16% you can't take from the employee. Then the provided that the further provided that further that the fresh option shall be exercised by the member within the period of 6 months. It means that if you have seen the last para 11.3, so in 11.3 there was no cutoff date, that there was no time limit that you have to intimate to the authority. But in this 11.4 there was the stipulate time where you have to intimate to the regional provident fund commissioner or up to the assistant provident commissioner or above that. So it was clearly mentioned over here, provided that also that period specific in the second provision may be sufficient cost being shown by the member, extended by the regional provident fund commissioner. So this was the difference between 11.3 and 11.4. In 11.3, it was clearly mentioned that if any employee want to contribute on the higher side in the pension also, they can do by taking the option 11.3. But in 11.3, there was no cutoff date. But in 11.4, there was a cutoff date. The employee who are eligible or who are taking this benefit, they have to intimate to the authority within the 6 months from the effective from the 1st September 2014 onwards. So now the second part start, because many queries has been coming from the existing employees also who has been retired prior to 2014 and who will be retiring soon. So this judgment is divided into two parts. The employee who is retired prior to 1st September 2014. So for them, it was mandatory to have the 11.3. So para 11.3 we have discussed. So employee has to give the declaration to the authority and it should be
can I just come in? No, just this thing. I thought probably I'll just summarize what was the August 22nd, 2014 notification.
Yes.
As you have gone in detail, just in 4 or 5 lines, and then you get into the Supreme Court, then probably that will be easier to appreciate. Sorry for coming in. So
yeah, sir, no problem.
Essentially, what Jay had gone through, if you can, there are 4 or 5 basic things that was the change made by the notification on 22nd August 2014, which is to come to, which was to have come into effect, or which has come into effect from 1st of September 2014. The first one and foremost is the threshold for the pension, maximum EPS payable was increased from 15,000, 6,500 to 15,000, and also the threshold under the para 2 FF also increased, so that you are as an employer supposed to contribute on more than or up to 15,000. Second, the one very important is that, which at that point in time nobody of us realized, but what was very critical is that those who are contributed, that was what he was explaining from 11.3, those who are already opted to contribute on pensions on more than 6,500 as on that date, were all given time of 6 months from the date of notification to continue to contribute on the more than 11,000, more than 15,000 if their actual salary was more than 15,000. So that is the catch. So it is not that those before 11.3 gave time for people to choose to contribute on higher pension any point in time. There was no time limit. But on the 22nd August, September 2014 notification curtailed that, and then very clearly said, if you have already chosen and opted to contribute on higher, more than the ceiling, if you want to continue, you need to intimate, take a confirmation within 6 months that you are going to continue. Not if your salary is more than 15,000, you are given a time limit of 6 months. That is the second point. Third point is the third point is the average, how the pension will be calculated. Till that point in time, if you retire, the salary, the calculation for pension is your last drawn salary, whatever is the EPS salary, into number of years of service divided by 70 is the thing. The number of years of service, the average salary was 12 months average salary from the date on which you are retiring or leaving the fund. But in this, they made it 60 months, that is 12 years average salary. So these are the major changes that brought in. And that is where a lot of questions came as to, people didn't realize at that time, and later in 2013, 14 and all that, people realized that they missed an opportunity. In spite of contributing on higher wages, their money is not going towards EPS. It is all going towards EPF only. So that is where all these issues back in, and then we ended up in the Supreme Court decision. From here, I think you can continue, Jay, so you can explain what is the Supreme Court decision. Yeah.
Yeah, just. So this was the golden rule for the employee who retired prior to 2014. That is from the on 30th August 2014. So for them, the golden rule is employee who retire prior to 1st September 2014 will get the higher pension benefit only employee has exercised the option under para 11.3 if their pension has been deducted on the higher side, that is above 6,000, 5,000 or 6,500 rupees, that is above the ceiling limit from the date of exiting the salary or from the first day when he was already exiting the 6,500, that employee can only take the benefit of higher pension only for the employee who retired prior to 1st September 2014. So in this, we have prepared one Excel. So date of retirement before 1st September 2014. Contribution, see here the word has been changed. Contribution on the higher wages, pension account number 10. If employee who has contributed the higher pension under para 11.3 not paid, for example, he has not paid on the higher side, not exercise the option, accepted by the never opted, then that employee is not eligible to get the higher pension, though his PF has been deducted on the higher side, but he is not eligible to get the higher pension. So here the pension wages contribute on the ceiling amount 6,000. His pension was deducted on the ceiling only 6,500 rupees and he retired. So he is not eligible to get the benefit. The second one is before 1st September 2000, he has paid the amount. So I just want to inform you the companies, some of the few companies are there in the EPF with the EPFO, their employees pension has been deducted on the higher side from the first day. Okay, they are already getting the benefit like in PF where we have to under para 26 we will discuss earlier. So right now with the EPFO there are few companies whose pension has been deducted on the higher side, so they are already, their employees already getting the higher pension. So the second one is the who have already paid never opted, they are eligible because their pension wages has been deducted on the higher side, but this is for the employee who retired prior to 1st September 2014. Then we come to the second part, that is the employee who retired after 1st September 2014 or who are still in the continue in the service. So maximum, I think you are getting the call from this employee only who are already in the continue of service and they are asking for the higher pension benefit. So for them, the golden rule is employee who retired after 1st September 2014 or continue to contribute under the or continue in the service and contribute under the para 26.6. So we will go what is we will go for what is 26.6. So this is the 26.6. No, anything contained in this para, an officer not below the rank of EPFC may joint request in writing of employee establishment to which this scheme applied. His employee enrolled such as member allowed him to contribute more than the 5,000, 6,500 or 15,000 rupees. The para 26.6. See, prior to this, we have discussed about the paragraph under EPS, Employee Pension Scheme, that was 11.3 and 11.4. But now, once again, we are discussing about the paragraph 26.6 of the Employee Provident Fund Scheme 1995. It means that the employee whose PF has been deducted on the above ceiling limit, that is 6,500 or 15,000, okay, they are eligible to get the higher pension under the para 26. But this was not applicable for the employee who retire prior to this notification, that is from the 1st September 2000. Prior to 1st September 2014, they are not eligible. But employee para 26(6) will be applicable जिनका भी PF ज्यादा डिडक्ट हुआ है. So this is the one chart we have prepared. That is the date of retirement, retired between, and here we have changed the language. Here we have mentioned that contribution on higher wages on the PF. If you see the prior earlier slide, it was the higher wages on the pension, but now it was higher wages on the PF, that is under para 26(6) of the Employee Provident Fund. Retired between 1st September to till the judgment was there. He has paid the PF on the higher side, never opted. In 11.4, it was mentioned that any kind of intimation, so never opted. Option given to apply within. So for this employee, okay, option is there to apply for the higher pension within the 4 months before 1st May 2022. He is eligible to get the benefit. And PF, example, PF wages contribute on the ceiling. No, it is to get the benefit of higher pension. The second, we will go for this, retire between the first paid, and he is also exercised there. I don't think so that no company has been given the application under the 26(6). But if any company has given the application under 26(6) to the authority, the exercise option between this rejected or not responded by the authority, he is also eligible to get the higher pension. The third one is retirement between the first 9, not paid. He has not paid on the higher PF has not been deducted on the higher part. Then he is not eligible to get the higher pension because he has not done the contribution. जब आपने higher पे deduct ही नहीं किया है, then you are not eligible to get the higher pension. The third one is joined on 1/9/2014 and continue in service. Paid, never opted. Option given, and so for him option has been given to get the higher pension because he has contributed on the PF has been deducted on the higher wages, that is above 15,000 or 6,500. he is eligible to get. Then joined before the 1st September 2014 and continue in service. He is already paid the amount on the higher side. PF has been deducted on the higher side. For them also, there is an option to divert that fund from PF to pension and get the benefit of higher pension. The last one, joined before 1/9 and continue in service, but he has not contributed on the higher side. This employee is not eligible to get the higher pension. And the last one, join on or after. So after, if any employee join after 1st September 2014 and his basic is above 15,000, that employee is not eligible to be the member of the pension. So this was the explanation chart from our side. And sir, now I want to move for that calculation part. Sir, your mic is mute.
Can you hear me now? Yeah.
Yes, sir. Yes.
Now, I just wanted to give a quick summary of what is the controversy decided by Supreme Court, right? Yes. So essentially, the contention was. So what are the three things? We saw that four things. I missed that 1.16 part of it. your threshold, the 11.3 before the amendment allowed you to choose to pay on higher wages any point in time, literally, or whenever your salary crossed. So pre-amendment, employees and employee can jointly exercise the option to make contribution on the actual salary exceeding the maximum penalty any point in time.
Yes.
That was restricted in this thing in 2014 when the threshold increased 15,000 and they put a time limit. Two conditions should have been fulfilled. One, on that date, you should have been already opted to contribute for more than the ceiling, which at that point in time was 6,500. Two, you should have opted to continue to contribute beyond 15,000 within 6 months. This is the basic problem. And then the other one, which I didn't mention last time, which I'm saying now, is that 1.16, which Jay dealt with in detail. If you opted to contribute for pension for more than 15,000, up to 15,000, 1.16 will be borne by the government. After that, beyond 15,000, it has to be borne by the employee who is choosing to contribute on more. So these are the so what happened was one of the employees, Shashi Kumar, has become the famous name here. He took the matter to the court, and the Kerala High Court said, you cannot, Kerala High Court, when it comes to the timeline given to choose an option, they said it's a classification. That is, you are dividing employees between those who have already chosen and those who are not chosen. And even if those who are chosen, you are given them time place, that's an unreasonable classification. And therefore, that is not valid. And relied on R.C. Gupta, this thing, and requirement to make additional contribution. Overall, Kerala High Court said the entire 2014 amendment is null and void or ultra vires the act. So finally, Supreme Court came in and then said, it is not ultra vires. The government was reasonable in coming up with the timeline. But considering all this has happened, we give them 4 months additional time for those. Again, they need to fulfill the 11.4 condition, not the timeline condition, but the condition that they should have already been contributing on the higher salary. They should have continued to contribute on the higher salary. For them, they get a timeline of which was 4 months from the date of judgment, which is 11th, November 2022. Now it has been extended up to May 2023. So after that, to implement it, the government came with a lot of notifications. That is what Jay will explain in the next couple of slides. Thanks, Jay.
Yeah. Sir, screen is visible?
Yeah.
Yes.
So what Jay is attempting here is, who could choose this option? Is it so he is giving a very I think he has taken one real passbook and then trying to give a context whether who should choose this thing. Go ahead, Jay.
Yeah, sir. So I have taken the passbook of one of the employee who is working from who is eligible to get the higher pension. So we have taken this, and so this is the passbook that is from 10th October 2010 onwards. The contribution has been started in this. So that was 33,000 rupees. The PF has been deducted. The pension is deducted, that is the 541 rupees, because at that time the ceiling limit was 6,500. So 541 goes into the pension amount, and remaining amount goes to the 3.67 plus difference amount, whatever difference amount move to the PF amount. So if you will see the in entire tenure that till 23, that is the March 23, I think we have taken January 23 months. Okay, till the date his contribution was only 2,96,264 rupees in the pension, and When we have diverting, like if anybody want to go for the higher pension, then they have to divert their PF fund to the pension fund. So in pension fund, what we have done is, this is the per month contribution. This is already 12%. So we keep this 12% here only. That is 33,252 rupees is going from the employee side. Then 3.67, this is the big catch over here. Prior to this, if you will see, 32,000 was going under the PF, but now it is only the 10,000 rupees is going. And in pension, 541 rupees is going, and now it is going 23,000 rupees is going. So what we have done in this Excel file is, so what we have done is, this is the 12% from the employee side, 3.67% from the company side, then the pension, total PF, and the PF loss, that the contribution total loss. Prior to this, there was a 32,000 rupees per month. It is going under the 32,711. 711 is going under the PF. Now it is going only 10,000. So it is a loss of per month. That is the 22,541 rupees. So what we have done, the according to the passbook, we have calculated. So this is the per month loss he is getting in the PF, and this is the cumulative loss he is getting per month wise. Like first month it was 22 only, then second month it will be added. So if we will see the PF loss in this 11 years, it is 1 crore 63 lakh rupees is the PF loss. And the contribution under the pension prior to this, whatever is going on right now, that is 541 and 1250. So total contribution was 2,96,000 in the pension, and now it has been increased to 1 crore 65,000. So now we will go for the calculation part. Just you have to keep in mind the PF loss is 1 crore 63 lakh rupees. So here I have prepared one Excel part where the pension wages into number of years of service divided by 70. So if we will go for that passbook, so if employee start his pension from 2022, from the December 2022, and end up, that is after death at a age of 15 years, like he retired at 60, or then the 15 plus year we have calculated that anybody live up to 75 tak wo unki age rahegi. So the monthly pension is coming, he can earn by contributing that 1 crore 65. The monthly pension will be 2,92,970 rupees per month pension. Then per annum it will be 35. Total pension is in the 15 years, I'm talking about the 15 years, it will be this much, 5 crore 27 lakh 34,000. But this is not tax free. So averagely I have calculated it will be more than 20%. Then also I have calculated on the senior citizen and everything, I have calculated the tax is only 20%. So you will get the pension, monthly pension in 15 years is 4 crore rupees you will earn. But in between, once you death, the primary pensioner will death, his nominee will get the 50% of the pension. So that also I have considered that the 15 years additional. So overall 15 years, but that pensioner nominee spouse will get only the 50% of the actual pension. So that comes to something 2 crore rupees. So overall, can if you will go now, then 6 crore rupees he will get in that 30 years of tenure, because his wife will death at 52 yani or 15 saal yani at the age of 80 85 उनका भी डेथ हो जाएगी, तो उनको टोटल मिलाकर 6 करोड़ रुपीस कंट्रीब्यूट होता है. सो दिस इज द मंथली पेंशन ही विल गेट इन द 30 years, 6 crore rupees. Okay, but now we come to the PF part. So as we have discussed earlier, there is a loss of 1 crore 63 because that moved to the pension part. If he keep the 1 crore 63 lakh rupees, then the interest lost will be the 98 lakh rupees, because what we have done, because in last whatever the benefit in this, we will share this Excel file also. So we have taken the actual part only, whatever the contribution has done, accordingly we have taken the interest. So on contribution he will get the 98 lakh rupees as a interest. So the overall corpus at the time of retirement, he can withdraw the amount of 2 crore 62 lakh rupees. And if he kept in the fixed deposit, if this amount will kept in the fixed deposit, we can consider the interest amount 7% only. But in that also, I have considered 1.40% is the tax will be deducted. So overall 560 will be there for 30 years. So he can earn 13 crore rupees, but this is the compound, Madhu sir, this is the compound we have done, that he will not utilize any money, and he will deposit the same amount what he is getting every month, he will deposit that also. So overall he will get the 13. But in second, we have considered that he is utilizing the money for livelihood. So 2 crore, 7% and 30 years. So he is eligible to get the PF loss amount, that he will utilize this amount 2 crore 62 lakh rupees he will get in the 30 years. So he will utilize this amount. Then also he is getting the 4 crore 40 lakh rupees, sir. And the biggest part is death होने के बाद in pension, if any employee death is there, primary employee death हो जाता है और spouse का, children will not get any benefit of this. But in this fixed deposit, his family can utilize this fund. So this was the perception of mine. So this is the comparison for the pension as well as the PF core plus.
Very interesting. So the point here, Jay, is, and for all the people on this thing, it will whether you, first of all, whether you are eligible for pension based on the Supreme Court is itself is a complex issue. Once you are eligible, and another point which me and Jay missed adding is that on the 26/6, the online form now insists that every employee who is chosen should produce proof that he has submitted form consent and the PF acknowledgement, that 26/6, whereby you are chosen to contribute on more than the ceiling is has to be uploaded. Now that is obviously every one of us will know. PF happily EPFO accepted when whoever wanted to contribute, they never insisted on this form. No, literally to my knowledge, no employer has gone and taken an approval here. And now insisting is not fair, and it is accordingly reflected in the Cochin High Court decision, which came on 12th of this month, day before yesterday, I think, or this. So very clearly they have said by the action that you have accepted this money, and there was a circular itself in circulation. The EPFO itself has said that if you have accepted it, is amounts to deemed consent. Now, though that is withdrawn, eventually it proves that you have taken the money, and therefore you should not put that as a condition for those now eligible to obtain the pension as per the Supreme Court ruling. So, but then based on that, has the EPFO changed the form and all of that? I don't think so. So even now they may be insisting online, but now it is a court decision. Once the court copy of the court, this thing is delivered, probably next week, within 10 days, they are supposed to change the form. That way. So having said that, so that's the overall legal aspect. On this calculation, if you are eligible, and it is a decision that each one of us need to take as to whether what is advantageous. This thing. One thing is very clear, as we demonstrated. If you take the money from, because the new pension is not being given from somewhere else, it is going to be given from your own corpus, which is now in EPF, will be shifted to EPS. But once it goes into EPS, you will only get a monthly pension, which means you will not be, what you would otherwise got as a lump sum on retirement will not be available. So that's a significant sum, because he has shown you in this thing, the amount that will get removed from your PF into EPS to give you monthly higher pension will be a significant. Yes, you will get a significant pension also. It's not that thing, but it depends on each one's expectation. What the other, therefore, no one is confident of living certain things. Something were to happen immediately after your retirement, and you are chosen for pension, then your near ones, your survivors have lost out on a huge amount of corpus. So that's one way of looking at it. There as, or you say, no, my situation is this, I don't have children, or they may not take care of me. So rather than getting an immediate benefit and then looking at investment, I'm okay to get a higher pension, even if it means post my this thing that is lost out, is an individual decision that each one of us needs to make. The other aspect is tax, right? As of today, PF withdrawal is tax free, but annuity or a pension that you get is taxable. Okay, you will be subject to old man, I mean, senior citizen benefits and all of that stuff. Probably next year in the budget, they might change. I'm just saying. So you will end up losing quite a bit of an amount on tax also. So it's a decision that people need to take on their own individual basis. I think we are now at 4:45. We will leave the floor open for questions. And there were a few questions which has already come by mail. Should we take that? Abhishek, can you?
Sure, sir, sure. Before that, we got one question on our chat box from Gurmeet Anand. The question is how to provide documentary proof prior to 1/6/2001, one basic salary more than 5,000, no PF ledger available on PF portal of this period.
Yes, this is going to be Ajay. I mean, Jay has much practical experience, but from my perspective, I will just add, and I will ask Jay to add. This is going to be a practical problem all of us are going to face, because on the portal, the way I understand is you need to give your past employers details and all of that. And yes, if there are in this thing, this fact that the 5,000, more than 5,000 was contributed before the time we got onto this passbook and all of that stuff, it's going to be a challenge. Form 3A and 6A will be the proof that will be required to be updated during for that time. You may have to work with your current at that point in time, who's the employer, and probably coordinate with them. It's going to be practically almost an impossible task if you have really moved on. And what if the employer is not in existence now? I don't know how they were going to do it, but I have not seen any clarification. Jay, you want to add on that?
So, same view is there, because when there will be a benefit, taking the benefit who retired prior to this. So we are also giving the form 3A and 6A, but that is also not notified by the EPFO. So fresh form 3A and 6A being submitted by us and going for the pension part. And they are accepting because the declaration is given by the company, but maybe it will create a problem because that was the 541 was deducting at that time. So now if we are deducting a higher type, then it will create a problem, and we are already facing this problem.
Yeah, so practically it's going to be a Herculean task for to ensure all your periods that contribution or whatever you have contributed on higher to prove that is going to be a task. And it's going to be a task for EPFO as well. And in one of the interactions through, I don't know whether it is ISF or CI, I was told saying that EPFO is not maintaining this data and they are expecting the employer to substantiate this. So it's going to be practically an issue for every one of us who is going to claim this. Yeah.
Sure. So, sir, next question is, please let us know what is the calculation of amount which will be adjusted from the fund for higher pension under EPS.
Okay, I'll take a stab. Jay, can you confirm?
Yeah.
So essentially, assuming that you have been contributing on more than 15,000 as on 1/9/2014, and so what would have happened as
meeting?
What would have happened if if let us say you are contributing on 20,000 rupees, your the EPS contribution would have been the 1,250 on your up capped at 15,000, balance all the 3.67 balance and the employee contribution would have gone to EPFO. So now what will they do if all you overcome all these hurdles and then you are able to get into the pension? What they will do is they will split the EPF balance and they will take 8.33% of your actual salary on which you have been contributing, move that to EPS corpus. What will then mean? That is why he was saying the substantial reduction in your EPF corpus will happen, and a similarly substantial addition to your EPS corpus will happen, which you will not be able to access as a withdrawal. You will get that as a monthly pension. So I hope I am clear. Jay, you want to add?
Yes, sir. Yeah, the same one. The whatever amount is there in the PF, they have to divert it to the pension amount by filing the form revised form 3A and submit to the PF department. Sir. Correct.
Now the next question on the chat itself. If any employee was contributing an higher PF prior to 1st September 2014 and also contributed above 15,000 on or after 1st September 2014, whereas during few years capped to 1,800, again contributed to higher PF, whether they are eligible for this option. And what is JD under para 26 bracket 6 if is not approved by EPFO?
Okay. So if there is a break and then you have not contributed, my understanding of the situation is that you will not be able to take the benefit now, unless, Jay, I'm not sure whether there is an option for the employee to kind of go back and recontribute and then make it good and all of that stuff. And can you, from your experience practically dealing, you are the one who is interacting on a day-to-day basis with RPCs. Can you add?
Yeah. No, sir. In this, two question is there at a time. The one is the JD they have submitted. Joint declaration, but it has been rejected by the department. But practically it can't be possible because doing the revision, even the employer has to face the 7Q and 14B. Because on the higher side, if they are contributing, then they are facing the 7Q and 14B. So practically, it is not possible to revise the things. But as they have said that, for example, in company A, your basic was the PF was deducted under para 26.6, that is on the higher side. In B also same, and in C there was a capping. Then you are not eligible to get the higher pension because that is the break once again. Throughout the thumb rule is throughout your membership, PF membership, it should be on the higher side. If there is the ceiling part, then you are not eligible to get the higher pension.
Okay, Abhishek, next.
Now, sir, next question from Deepak Patil. Now, last date of document submission date is 3rd May. Those are want to higher pension. And second part is what attachment we need to submit.
Jay, you want to take it?
Yeah. See, there are just a minute. I will share that also. It is visible, Abhishek?
Yeah, I can see you. I can see you.
Yes.
So as discussed with Madhu sir, the important part is the document part. This is the part whether the employer contribution was received wages that is 5,000 prior to first whatever. So you have to click. The second important, please attach the permission That is the para 26.6 of the EPFO. So Madhu sir, in this, what we have done is we are also attaching one declaration file that till the date we have not intimated, but till the date our PF has been deducted on the higher side, and you have also credited the interest on this. Though, so we are just submitting the declaration part. So this documents we have to submit under para 26.6. Then the second part is the whether the employer contribution received exceeding the statutory limit EPFO. And once again here we have to upload the same declaration part. So what I can do is, Abhishek, I will share the declaration also with you, and two forms are there for the employee who is already in the continuous service and they want to divert their fund. So I will share the this form also. The same thing they have to upload on the EPFO portal. And this is the, I will share the link also. But this all documents they are asking to submit online.
Sure, Jay. I will share this with Mr. Deepak. Next
I
question
think
is.
there is only one caution because of the Cochin High Court decision, there could be some change in the online form and declaration.
Yes,
so
right, sir, right.
So next question is from Mr. Chandras Reddy. What if my next employer doesn't allow to contribute beyond capping wage and pension will be on last 60 months average salary?
That's a good question. That is for somebody who's opting for it and then who has still got some service left. And if an employer, they say, that is why I think, see that if your future, if it is a future employer or your current employer is going to change policy, I think it is between the employer and employee. They need to clearly understand that, boss, I want a future this thing, and accordingly, please contribute on my this thing on my complete salary. Then it becomes the calculation of CTC, right? So whatever is going to be any other component that has to be added to this part, and if that is a choice, that's the only way I see it going, right? So it's going to be a negotiation between, and I don't think an employer can say no when, if you're willing to give up some part of CTC for higher this, because at the end of the day, it's not an additional cost to the employer.
Sure. And next question is from Mr. Gurmeet Anand. I have submitted my application for higher pension. How will we know it is accepted or not?
Yeah. Once you, Gurmeet, once you submit the application, you are getting the acknowledgement. So right now there is no option is to check out, but acknowledgement slip is with you. So as Madhu sir has already informed that there must be some changes regarding the documentation part of the 26.6. So I think it will be uploaded. The application number will be shown on the website. Just you have to mention the application number and you come to know that what is the status of your higher pension.
Now, sir, next question is from Mr. Nishan Bhatia. What about the employees who worked before UAL launch? How do service details will capture in filling the joint option form?
I think we have answered this. So that is where I think your that times form 3A of your this thing is what going to be the attachment. That will have all the details, and based on that you need to fill up the form. Am I right, Jay?
Yes, sir. Yes.
If application is rejected on ground of any missing attachment, can we apply again?
Sir, is.
Yeah, I think, see, we don't know. Probably yes, you should be able to apply again, or there as I think as more and more people apply, and then they may be based on experience. Even if that option is not there, they may allow that again. Yeah.
Sure. I request participants, if there are any more questions, we still have 3 minutes left for this webinar.
There was a couple of mails which has come now, Abhishek. Can we take it up?
Just give me a minute, sir. I will just. So I'm just sharing my screen. We have received one question from Mr. Shashi. Is my screen
Instead
visible?
of sharing screen, can you
Sure,
read out
sure.
the question, please?
Yes. So Shashi has worked in 3 companies post 1995. ICICI Bank 12 years, Oracle 3 years, and currently IDBI Infotech for 12 years. And he is having enough balance in PF account and ready for deposit for any shortfall. He have withdrawn PF against ICICI and PF and EPS against Oracle. However, on an inquiry, EPFO Bandra has told him that I have withdrawn EPS too. To my understanding, to my understanding,
EPS can be withdrawn if service period is less than 10 years. Yeah.
But in sir,
to my understanding, EPS can be withdrawn if service period is less than 10 years.
Abhishek,
I
think
do not
it's
have any.
here, the most important fact here is one, was he contributing above 15,000? I don't have that information. Without that, it will be difficult to give this answer. Second, if he had withdrawn EPS, then there is no contribution there. Okay. And I'm not, even if let's say he is contributing on higher pension, once you have withdrawn EPS, which is that you are not taking pension, there is no corpus left there. I don't know whether you can now again pay back and take it. I don't think that option is available for him.
So Shashi Kumar has you wrote that he has contributed above 15,000. I request Shashi Kumar if you can directly ask your
Right
question to
person.
speakers. Just
But
unmute
for the
yourself
general
and you can ask.
views, my sense is that even if you contribute, if you have withdrawal from EPS there, I don't think you will be eligible, because to be eligible for EPS also there is a minimum contribution, that is number of years is 10 years. If you have broken it, then
sir,
taken a scheme certificate.
See, that is the point basically. In ICICI, I have a 12 years of experience, and ideally I should not have been even allowed to withdraw. But physically, when I gone there and inquired, they are told that the record is for some 3 years or something only, and it has been already withdrawn. Okay, and I have asked for details and all sort of thing. So my question is basically, if the amount is withdrawn from EPS also, then that period cannot be claimed for a service, even the money is paid back, right?
I don't think so, sir.
Hello.
Yes.
You are able to hear me?
Yeah, I can. I'm hearing you. Are you able to hear me?
Yes, sir.
So you are right.
Yes, I am able to hear.
Once you withdraw, I don't think you will be able to get this higher pension.
yes.
Okay, so I have to just clarify on how whether it the withdrawal has actually happened, and if it is withdrawn, then I basically I should not go for it, because for a limited period, it is not beneficial for going to a higher pension.
Yeah, all that you need to take into account before you take this call.
Okay. Okay, sir. Thank you.
Now, I believe it can be a last question from Nishan Bhatia. Do you have any screenshot or PPT to fill joint option form?
No. We have the forms, declaration forms and everything, and one PPT that how what are the documents you have to upload, that we can share, because इसके पहले जो दिखाया था वो वही था. What are the windows come step by step. We have that PPT, and we will share the forms also, that what are the forms they have to upload with this.
Okay.
Sure. So we are already getting many.
One hand raised, Sadiq Ahmed.
Sadiq.
We can with that we can conclude.
Sadiq, can you hear me? You can just unmute yourself and ask your question directly to speakers.
Yeah, thanks, Jai. Thanks, Madhu, sir. Sir, question to you only, sir. I think having all this understanding, what we have got from insight at loss of PF potential loss of the PF contribution when we go opt for the NPS, basically that EPS pension, right? So, but the market perception, some employees are there, some individuals are there who want to still go for the EPS scheme. Okay, so what they're doing is they want to understanding when it compared with other pension schemes, right? We have NPS is there, right? National Pension Scheme, or any other banking pension schemes which they come up. So comparatively, if you see like in the market where the pension schemes are there, so do you still see that PF EPS is kind of over and above them, or still it's been kind of compensating each other kind of thing? When you give a comparatively see the pension schemes available, which is the best, like you would have kind of.
I am not an expert, but I can give you this much. So all your pension products from, let's say, an insurance company where you have taken a separate policy towards it and all of that, is depending upon the interest rate at that point in time and what the insurance company is expecting the interest rates to be. And accordingly, they will give you an annuity amount, right? And how much, see, then there are, for example, they will give you an option, commute some apart, commute this thing and all of that. So it's very difficult to compare, because here EPS pension goes by a formula. Your average salary for 60 months into number of years of service divided by 70. Okay, I think that formula will always work out better than what an insurance company, again, depending upon the interest rate that point in time, what is the value of money the insurance company is calculating over a period of your lifetime, and accordingly willing to give you as an annuity, probably will be lesser than what an EPS pension will be. But I don't think we can make a guess and do that. It has to be a calculation on your own contribution, what is your balance, etc. put together.
Got it, sir. I got the insights. Thank you so much for that.
Is there any other questions? We are already out of time, running out of time. So I request all the participants, if you have any further queries or questions, you can just drop a mail to ISF Secretariat. We will try to get the answers from our eminent speakers and share it with you. So for today's session, I really thankful to Mr. Madhu Damodran and Mr. Jay Shah to be an eminent speakers and to share their insights on this crucial topic. Thank you. Thank you, everyone.
Thank you.
Thank you, Madhu sir.
Thank you, Jay.